सप्रेम जय महाराष्ट्र. महाराष्ट्रभरातून शिवसेना एक वादळ या माध्यमाला पाहणाऱ्या तुम्हा तमाम प्रेक्षकांना, सर्व शिवसैनिकांना माझा अनिश गाढवेचा मानाचा जय महाराष्ट्र. जर हे माध्यम आपण पहिल्यांदाच पाहताय, ताबडतोब या माध्यमाला सबस्क्राइब करा. महाराष्ट्रभर शिवसेनेच्या विचारांना पोहोचवणाऱ्या या माध्यमाला तुम्ही सर्वांनी मिळून मोठं करा ही नम्र विनंती करतो. शिवसेनेचं नाव आणि शिवसेनेचं निवडणूक चिन्ह धनुष्यबाण या संदर्भातली कालची सुनावणी केवळ 5-10 मिनिटांसाठी, केवळ नावापुरती सुनावणीसाठी आली असं अनेकांचं काल मत झालं. पण तुमच्या माहितीसाठी सांगतो, ही सुनावणी जवळपास काल 1 तास 28 मिनिटे चालू होती. शिवसेनेच्या वतीने श्री कपिल सिब्बल, शिवसेनेचे वकील, यांच्यातर्फे 1 तास 28 मिनिटांचा युक्तिवाद चालू होता. यामध्ये न्यायाधीशांकडून अनेक प्रश्न विचारण्यात आले. 1 तास 28 मिनिटांच्या या युक्तिवादात नेमकं काय काय घडलं तुम्हा सर्वांसमोर आहे असे काही प्रसंग मी ठेवण्याचा प्रयत्न करतोय. ते व्हिडिओ सुद्धा दाखवण्याचा प्रयत्न करतोय. आता लक्षात घ्या, जेव्हापासून ही सुनावणी सलग चालू आहे, आपण पाहताय दरेगावचे फेरे वाढू लागलेले आहेत आणि दरेगावच्या फेऱ्यांनंतर आता दिल्लीचे फेरे चालू झालेले आहेत. खासदारांची संख्या दाखवणं, राज्यसभेचे खासदार उभे करणं, लोकसभेचे खासदार उभे करणं, चोरून आणलेले काही खासदार उभे करणं, हे दाखवून आपल्या पक्षाचं अस्तित्व वाचवण्याचा एक प्रयत्न करण्यासाठी शेवटची धडपड मला सुरू दिसते. आज मी काही दिल्लीचेही फेरे बघितले. असो, तो आपला विश्लेषणाचा भाग नाही, पण तरी एक गोष्ट लक्षात घ्या, आत्ताची चालू असलेली सुनावणी, ज्यावेळेस न्यायमूर्तींचं सुद्धा हेच म्हणणं होतं की आम्हाला भविष्यासाठी निर्णय घ्यायचे आहेत आणि आम्हाला अपात्रता ठरवायची आहे. अनेक प्रसंग घडलेत कालच्या त्या संपूर्ण सुनावणीमध्ये. ते 1-2 प्रसंग मी तुम्हा सर्वांसमोर आहे असे व्हिडिओच्या द्वारे ठेवण्याचा प्रयत्न करतोय. सगळ्यात प्रथम लक्षात घ्या, शिवसेना मुख्य नेते हे पद जे सध्या एकनाथ शिंदे यांच्याकडे आहे, मुख्य नेते अशा प्रकारचं पद आहे. शिवसेना मुख्य नेते म्हणजे पक्षप्रमुख पदाला एक समांतर पद उभं केलं गेलं, ज्याची कुठलीही सबमिशन्स म्हणजे 2018च्या घटनेच्या त्या बदलामध्ये कुठलेही तशा प्रकारचे अमेंडमेंट करण्यात आले नव्हते. शिवसेना मुख्य नेते म्हणून पक्षप्रमुख पदाविषयीचे सारे सबमिशन्स या अगोदरच ऑन रेकॉर्ड आहेत. या सगळ्या गोष्टींवर काल थोडा घटनात्मक केस पडला. काल या सगळ्या गोष्टी तिथे समोर आल्या. कशा प्रकारे मुख्य नेते हे पद पक्षाची कुठलीही कार्यकारिणीची बैठक न घेता हे सारं तिकडनं गुवाहाटीतून झालं. जरा ह्याच्यावरचा हा पहिला व्हिडिओ पहा.
The post of Shivsena Paksh Pramukh as the party president is cancelled with immediate effect. All the powers and duties of party president will now be held and executed by chairman of the Rashtriya Karyakarani, also known as the Mukhya Neta. Mukhya Neta is Shinde, Mr. Shinde. The title of Shivsena Paksh Pramukh will remain with Shri Uddhav Thackeray till he desires, but it will be an honorary post. So they themselves changed the constitution of 2018. And the argument is, no, that constitution doesn't exist. And the 1999 constitution will apply, but the 1999 constitution doesn't have any of this. So I will discuss the 2018 constitution. I will not look at it. So no organizational structure. I'll go by the legislative majority and you are the party. That's the logic. Now kindly see page 407, which is this resolution. And see subject number 1 there. This is the minutes of this meeting, Malaj. To change, amend the constitution of the party. And Malaj, kindly note one fact. The 1999 constitution is not the original constitution. That's also amended. And this is amending in 2022. They say so. 2018 constitution is being amended. Yes. So, Malad, that's where we are. Then for what?
हे व्हिडिओ मी तुम्हाला यासाठी दाखवतोय कारण कोर्टाच्या आतमध्ये नेमकं काय घडत असतं, त्या सगळ्या गोष्टी कशा असतात, कशा प्रकारे वकील आपले म्हणणे मांडतात, कशा प्रकारे जजेस रिॲक्ट करतात, कशा प्रकारे तिथे वातावरण असतं, हे याचं सर्व चित्र तुमच्या समोर उभं राहतं. त्यासाठी हा व्हिडिओ दाखवण्याचा प्रयत्न. आता पुढचा महत्वाचा युक्तिवाद पहा. म्हणजे पक्षाची राष्ट्रीय कार्यकारिणी जिला विचारात घेतलं नाही, पक्षाची घटना जिला विचारात घेतलं नाही, पक्षाच्या घटनेमध्ये राष्ट्रीय कार्यकारिणीचं महत्व ज्याला विचारात घेतलं नाही, ते इथे कपिल सिब्बल यांनी फूट घडल्यानंतर सुद्धा त्याचं स्वरूप काय होतं, कोण कुणाच्या बाजूने होतं, किती संख्या कुणाच्या बाजूने होती, हे कशा प्रकारे तिथे ऑन रेकॉर्ड भर पुराव्यांसह दाखवलं, याचा सुद्धा एक व्हिडिओ दाखवतो. हा व्हिडिओ खरं तर चेंजिंग ठरणार आहे, संपूर्ण गेम चेंजिंग ठरणार आहे. कारण या व्हिडिओमध्ये आणि त्याचबरोबर एक दोन तुम्ही सोशल मीडियावर सुद्धा पाहिले असाल, त्यावेळेसचे काही लेटेस्ट सोशल मीडियावर व्हायरल झाले. 2018च्या त्या पक्षाच्या घटनेमध्ये जे काही बदल घडवले गेले, नव्याने बदल घडवले गेले, त्यावर कशा प्रकारे अनुमोदन, मग तुम्ही पाहाल उदय सामंत असतील, दादा भुसे असतील, रवींद्र वायकर असतील, यांची नावं आणि यांच्या सह्या आहेत त्याच्यावर. कशा प्रकारे ज्यानंतर 2022 मध्ये म्हणजे जून 2022 मध्ये 21 जून 2022 मध्ये ज्यावेळेस एकनाथ शिंदेंनी हा संपूर्ण कांड घडवला, त्यानंतर सुद्धा एकनाथ शिंदेंची गटनेते पदावरून ताबडतोब तिथून तुम्ही म्हणाल त्यांचं नाव कमी करण्यात आलं, त्याच्यावर सुद्धा उदय सामंत, दादा भुसे, रवींद्र वायकर यांच्या सुद्धा सह्या त्याच्यावर आहेत. या सगळ्या ज्या गोष्टी आपण ऑन रेकॉर्ड ऑन पेपर केलेल्या आहेत, या सगळ्या गोष्टी एकनाथ शिंदे यांना, त्यांच्या वकिलांना ज्यावेळेस कोर्टामध्ये त्यांची बाजू त्यांना मांडायची असेल, त्यावेळेस मात्र या सगळ्या गोष्टी भारी पडणार आहेत. तुम्ही एकदा हा व्हिडिओ पहा. या व्हिडिओमध्ये कशा प्रकारे राष्ट्रीय कार्यकारिणीचे कुठले सदस्य कुणाच्या बाजूने होते हे ऑन रेकॉर्ड पुन्हा घेऊन आणण्यात आलं. पहा.
Both the parties filed affidavits demonstrating support enjoyed by them in organizational wing and legislative wing. The petitioner was able to demonstrate overwhelming majority in the organizational wing of the party through the affidavits of support as summarized below. So as far as the representatives in the national executive are concerned, the Uddhav Thackeray had 160, they had nil. Then Rajya Prabhari, Chief of States, 18 and 11. Office bearers in the organizational structure, 2,83,135 and nil. And primary members, 19,41,000, they had 4,48,000. Amongst the office bearers from the 2018 organizational election, the status of support enjoyed by the petitioner was as follows. Kindly come to 433. This is very difficult to read. Just minutes. It's better to read the printed, typed portion at page 15. Elected leaders. Out of the 9 leaders, 1 had passed away. Petitioner had support of 6 out of the remaining 8. Elected deputy leaders. Out of 21, 3 had passed away and 2 had left Shivsena. Petitioner had the support of 13 out of the remaining 16. Appointed deputy leaders, out of 12, 2 had left the Shivsena. Petitioner had the support of 7 out of 10. Secretaries, the petitioner had support of all the 5 secretaries. And similarly, the petitioner enjoyed support of overwhelming majority amongst the 31 Zilla Sampark Pramukhs, 92 Zilla Pramukhs, and all the 10 Vibhag Pramukhs. So therefore, obviously it was convenient to discard the 2018 constitution because the commission could not have decided based on legislature. So conveniently discard it, say it's not on my record, go to the 1999 constitution, say 99 constitution doesn't have any of these things, not this Karyakarani, not this organization structure. I won't look at it. Therefore, I won't look at the organization. Therefore, I'll go by the legislative majority. Well, how can a commission do that when both parties are saying that we are working under the 2018 constitution? Under what jurisdiction is the commission saying that? And under what law, Mullahs? I will demonstrate to your lordships, Mullahs, when I read 29A and the guidelines of the commission, they have no jurisdiction. And it's now there's a division bench judgment of the Delhi High Court which says that they have no adjudicatory power. They can't decide on the validity of the constitution. The maximum power they have is to withdraw the registration. And that's also an exception. That will be adjudicated. But they can't say your constitution is bad. And that under paragraph 15, when there's no jurisdiction to deal with it.
Democratic deficit. How can that?
They say there's a democratic deficit. All right. Then you just recommend to us that, look, correct it. And we say, no, all other constitutions, my lordship knows, all other constitutions have the same kind of provisions. But I'm not going to that because that's not the remit of the election commission. So you assume jurisdiction where you don't have it, and you decide the matter on the basis of that. Well, this is most unfair, Mullahs. That's why, Mullahs, institutions ultimately If they don't inspire confidence, this is what happens.
या व्हिडिओमध्ये आपण जे आकडे पाहिलेत, या आकड्यांमुळे शिंदे गटाच्या वकिलांना आकडे येण्याचीच वेळ बाकी राहिलेली असेल. कारण हे आकडे फार महत्वाचे आहेत. राष्ट्रीय कार्यकारिणी पक्ष कुणाच्या बाजूने आहे, राजकीय पक्ष, पॉलिटिकल पक्ष नेमका कुणाच्या बाजूने आहे, हे आकडे स्पष्ट करत होते. कार्यकारिणीच्या 160 पैकी 160 सदस्यांचा उद्धव ठाकरे यांना पाठिंबा होता. एकनाथ शिंदेच्या बाजूने 0. त्यानंतर 29 पैकी इतर राज्यांचे राज्य प्रभारी, ज्याला आपण चीफ ऑफ स्टेट म्हणतो, 29 पैकी 18 उद्धव ठाकरेंच्या बाजूने, 11 एकनाथ शिंदेच्या बाजूने होते. त्यानंतर पार्टीच्या पदाधिकाऱ्यांपैकी 2,83,135 पदाधिकारी हे उद्धव ठाकरेंच्या बाजूने, एकनाथ शिंदेच्या बाजूने त्यावेळी 0 पदाधिकारी होते. त्यानंतर पदाधिकाऱ्यांचे जे संपूर्ण राज्यभर पदाधिकाऱ्यांचे जे ॲफिडेव्हिट आले, त्यांची संख्या जवळपास 19,41,000 इतकी संख्या ही उद्धव ठाकरेंच्या बाजूने होती. किती? 19,41,000. आणि एकनाथ शिंदेच्या बाजूने 4,48,000 पदाधिकाऱ्यांचे ॲफिडेव्हिट त्यांनी जमा केले. आता पुढे बघा, नेत्यांपैकी 9 नेत्यांपैकी 1 नेते वारले होते, पण 6 नेते, उरलेल्या 8 पैकी 6 नेते हे उद्धव ठाकरेंच्या बाजूने आणि 2 नेते हे एकनाथ शिंदेच्या बाजूने होते. बघा, म्हणजे पार्टी कशा प्रकारे आपण प्रूफ करत होतो. त्यानंतर उपनेते, 23 पैकी 3 उपनेते वारले होते आणि 2 उपनेत्यांनी पक्ष सोडला होता. त्यामुळे उरलेल्या 16 पैकी 13 उपनेते हे उद्धव ठाकरेंच्या बाजूने होते आणि 3 उपनेते हे एकनाथ शिंदेच्या बाजूने होते. इथे सुद्धा मेजॉरिटी. त्यानंतर सचिव, पार्टी सचिव, 5 पैकी 5ही सचिव हे उद्धव ठाकरेंच्या बाजूने होते आणि एकनाथ शिंदेच्या बाजूने 0. इथेही मेजॉरिटी. त्यानंतर पार्टी राज्य संपर्क प्रमुख म्हणण्यापेक्षा जिल्हा संपर्क प्रमुख, 31 संपर्क प्रमुखांपैकी सर्वच्या सर्व उद्धव ठाकरेंच्या बाजूने होते. इथेही मेजॉरिटी. 92 जिल्हा प्रमुखांपैकी आणि मुंबईतल्या 10 विभाग प्रमुखांपैकी, मुंबईचे 10 विभाग प्रमुख आणि 92 जिल्हा प्रमुख यांच्यापैकी सर्वच्या सर्व हे उद्धव ठाकरेंच्या बाजूने होते. हे सर्व जे पुरावे आहेत हे इलेक्शन कमिशन ऑफ इंडियाने पाहिले नाहीत. मग कोणत्या न्यायाने इलेक्शन कमिशन ऑफ इंडियाने हा निर्णय दिला? हे सर्व बोलत असताना दिल्ली हायकोर्टाच्या एका जजमेंटचा त्यांनी इथे रेफरन्स दिला, ज्यामध्ये त्यांनी सांगितलं, घटना वैध की अवैध हे ठरवण्याचा अधिकार हा इलेक्शन कमिशन ऑफ इंडियाला नाही. घटना वैध अवैध, त्यांना जास्तीत जास्त हा अधिकार आहे की आम्ही तुमची मान्यता काढून घेऊ, म्हणजे पार्टीची मान्यता, रजिस्ट्रेशन आम्ही विड्रॉल करू, हा त्यांना अधिकार आहे. मग त्यांनी कोणत्या अधिकारांच्या अंतर्गत घटना वैध अवैध ठरवली? हे सारे आर्ग्युमेंट्स आज तिथे झाले. या सर्वाचा सुद्धा मी तुम्हाला एक जबरदस्त, म्हणजे हे कसे आर्ग्युमेंट झाले, कशा प्रकारे तिथे वातावरण होतं, एक चांगला मोठा व्हिडिओ दाखवतो, ज्यामध्ये तुम्हाला सलग ऐका. हा 10 मिनिटांचा व्हिडिओ तुम्ही सलग ऐका, ज्यामध्ये एकनाथ शिंदेंनी कशा प्रकारे अगदी थंड डोक्याने प्लॅनिंग करून एक एक गोष्ट घडवून आणली, हे स्वतः वकील कपिल सिब्बल यांनी व्यवस्थितपणे मांडण्याचा प्रयत्न केला. आणि इथे जजेसचे सुद्धा काही प्रश्न आले, ज्यावर कपिल सिब्बल यांनी जबरदस्त आर्ग्युमेंट केले आहेत. एकदा हा व्हिडिओ पहा तुम्ही.
So if this petition were to be decided, it would go back to 21st of June. If it goes back to 21st of June, then the question of even going to the commission doesn't arise.
That is, we would like a clarity on this point, because Mr. Sibbal, going through Subhash Desai, actually the Justice Chandrachud speaking for the bench makes an observation that voluntary giving up of membership under Rule 3 is not an automatic severance of tie in the political party outside the law.
Disowning the political.
Well, I'm not disputing that.
Now, if that is not so,
I'm not disputing that.
we fully understand your prioritization of the two exercises. That please have the disqualification first and thereafter go for the symbol.
We've lost that, so I can't possibly argue.
Academic in this particular case.
Yes, yes.
In another case, it's an open question.
Well, there's that.
But if you see it as it stands in the facts of this case,
Right.
what does the speaker decide? The speaker decides with regard to conduct of Eknath Shinde and his faction in June 2020.
Right.
Whether, firstly, not responding to a notice of the Pramukh to attend a meeting would amount to a act of.
That's only one. That's only one thing.
Just
Many things.
allow us to recount and correct us if we are correctly getting the facts. First is the act of the notice
Right.
that they were given notice for Paksh Pramukh's residence, they have to come. They, according to you, chose not.
That's right.
So that is a conduct which is in the nature of a challenge being thrown to the Pramukh and voluntary giving up of membership. Next is they are block move to a different state and allegedly hobnob with members of another political party. From that, move to another state and do the likewise. These are the two events which premise the disqualification.
No, more, Malas, more. More, not just that much. Passing of a resolution, appointing their own person as the whip. Well, many more instances. They appoint, Malas.
Yes.
Sunil Prabhu they remove, and Gogavale they appoint.
Gogavale is
They appoint another Malas in voluntarily giving up membership, right? They appoint, he appoints himself as the leader of the legislature.
These are after the application of disqualification.
That doesn't matter, Malas. The court says,
It matters. No, it matters. When you see disqualification, subsequent facts are not to be taken into consideration.
Malas, this court has now held that it is illegal. Malas, that finding is already there. Malas, once it is illegal,
Mr. Simple, what this court in Subhash Desai decides is not disqualification, but the decision of a faction in the legislative party appointing a whip or appointing the leader of the legislative party. This court holds that there is a connect between the legislative party and the parliamentary party is actually the superstructure on which the legislative party stands. And therefore, who would be the leader of the legislative party? It's the premise of the political party.
no, Malas, I just,
Where they strike down Mr. Shinde and his group's decision to change Mr. Thackeray's choice of Mr. Prabhu as the whip and so and so. That is one part of this case. The other part of the case gets remanded. There are three.
no,
parts.
Malas, thereafter, just one more fact, Malas. 16 people, against 16 people, we move on the 23rd. The balance people we moved on 22nd of July. So it's not just those two facts, Malas. We file it, kindly see.
We'll have to decide this.
That's right. For only 16, so that the facts are clear. We move against 16 on the 23rd of June. We move against the balance on the 2nd of July. So therefore, all events prior to 2nd of July, which will include what I have mentioned to your lordships.
Sharad Pawar case, Sharad Pawar's decision delivered by this court.
Yes.
There are two judgments.
Yes.
In that decision, this court clearly holds Justice Bhushan's judgment,
Yes.
not subsequent events.
Yadav, Manoj. Sharad Yadav's case, Manoj.
Sharad Yadav's case.
So I argue that matter, Mullah, myself.
My mistake. In Sharad Yadav's case, this court has held it would be the date on which you make the application.
Correct. So the
Application-
2nd of July.
Prior to that have to be seen.
But 2nd July, I'm telling your lordships, Mullah. But I'm saying that to your lordships. 2nd of July.
Consider
No,
that,
2nd of July, Mullah.
that if you are saying that it's a continuum of events,
No, I'm not saying. If you're, let's assume,
events will
Well,
also
I-
color the conduct.
for my purposes, I don't have to go into this. There's a disqualification application on 2nd July.
Another tranche of disqualification.
Yes, on the 2nd of July. So the very logic that your lordship is yes, will apply then.
What I am talking of is the 16 batch.
Yes, well, let's go.
That will be only in respect of the.
Doesn't matter. All right. But then what, the 2nd of July?
You can incorporate.
Then 27th June also. 23rd June, 27th June, and 2nd July.
But coming back to the symbols order, because the disqualification really, apart from maybe if you ask us that the findings are correct or not, really it will not have any impact on the decision.
No, but the speaker has decided against us. So he couldn't have, we are in appeal against that order. Yes, Malad, we are in appeal against that order.
It's infructuous because the
No, no, Malad, I'm sorry. I'm sorry. This will always stand in the way of the judicial decision. We are in appeal against that order. Your lordships will have to, you may say it has become infructuous but your lordships will have to still set aside that decision. That's my submission to your lordship. That's all that I'm saying.
I beg to appear in the connected matter, just to my lord,
the
my lord.
disqualification.
Yes, on the disqualification, my lord. Lord, your lordships have held, my lord, by a constitution bench in Rana, that, my lord, the order of disqualification, either by the speaker or when it is upheld by your lordships, relates back, my lord, to the date on which the prohibited conduct occurs. Right, my lord? Now, my lords, the decision, whatever your lordships will render in the disqualification case, has a direct impact on my symbol dispute, because as on the date of 22nd of June, they stand disqualified.
That's right.
Then, my lord, in the symbols order, which comes, my lord, on February 2023, the Election Commission, my lord, could not have relied upon legislative majority.
Simple, Mr. Kamath.
Yes, my lord.
This is the argument which we would request you
Yes.
to test in light of the earlier Subhas Desai judgment,
Yes, my lord.
where it says that the decision to disqualify a member on voluntarily giving up membership in the legislative party does not automatically amount to an ejection of the member
Correct, my lord.
from the political.
We don't dispute that. We don't
It is
dispute
not so.
We don't dispute that, Malad.
Mr. Shinde, even if disqualified from the legislative party, continues to be a member.
No
of
difficulty,
the
my lord.
version
But the
of-
problem is the Election Commission, in deciding the symbol, says that he is a majority of the legislators.
That
And
point-
therefore, my lord,
That's the point.
That's the only point on which the Election Commission has given the symbol.
That point today in this case does not become relevant because the decision had not been taken.
No, my lords. By your lordship's judgment, by a constitution
So
bench,
you want to say that if we
Yes.
affirm that it goes
it
back.
goes
to-
back, my lord. It goes back.
That's why I'm saying you'll have to decide this matter. This is an appeal, Malad. This will have to be decided. You may not, you may. Yes.
Lord Rana, I'll give the paragraphs.
Not just Rana, there's another three.
And also,
Malad.
There is no doubt
Yes.
because just Chandrachud makes two comments on Rana.
yes, my lord.
One is, it is true that we have to decide the disqualification. The question was, as both of you would be appearing there, that whether they could participate in
In
the
the
floor
legislature.
test or not when the.
Yeah, then your lord, they said, no, that you cannot injunct. Yes,
That the bench holds.
yes.
The decision operates prospectively.
That is in
but-
respect of
Let's
180.
back to the-
That's in respect of 189. There's nothing to do with this, Malad. Your lordship is right, but that's nothing to do with this issue. So this appeal is live because the whole election symbol is granted on this fashion. That's why it's live. Of course, yeah. Yes. 23rd June, 27th June, 3rd July.
If this disqualification.
Huh? And then 21B. Well, then, and then 21B, 21B is when they vote against at that, we are the party at that stage. So 21B also will apply. But that's now sidelined because a new election has taken place.
That cushion is gone.
Yes. Therefore, Malad, this matter will have to be decided because the basis of the commission is that. I mean, we cannot get any relief on that. Means he can't be.
Would incidentally get a relief.
Yes, exactly. So, Malad, the point I was making was these three judgments, which he cites, on the basis of which he assumes jurisdiction, he could not have assumed jurisdiction under paragraph 15. Because he assumes it on the basis that because there's a split in the legislative party, it's a split in the political party. Ex facie, that's wrong. If he can't assume jurisdiction, then on what basis did he move forward?
That is not the only reasoning given, but that's of course you are right, one of the reasoning given is like this.
That's the only reason, Malad. Thereafter, he says the legislative party, they had all the membership. Organizational election, I won't look at. I've given you those reasons. I won't look at the 2018 constitution. I don't look at the 2013. It's not on my record. I will not bother about that. Legislative majority, so symbol goes to him. That's the logic, Mullah.
So reasons are there, those may be good or bad.
No, but that's no reason. That's but that's no reason. Mullah, this is a very what should I say? Very well crafted reason, Mullah. It's a part of craft.
एवढी जबरदस्त आर्ग्युमेंट झाली. खरं तर कपिल सिब्बल यांनी ज्या प्रकारे जजेसच्या प्रत्येक प्रश्नावर जजेसला सॅटिस्फाय केलं, जजेस सुद्धा आपसामध्ये चर्चा करू लागले की आता याच्यावर पुढे काय काउंटर प्रश्न विचारायचा. आपण सर्वजण पहा, या सगळ्या गोष्टी तिथे ऑन रेकॉर्ड येत असतात. या सगळ्यावर नंतर आफ्टर द कोर्ट टायमिंग त्याच्यावर नंतर खलबतं होत असतात. त्याच्यानंतर त्याच्यावर ब्रेन स्टॉर्मिंग होते. आता ही 3 सदस्यीय खंडपीठ आहे. या अगोदर 5 सदस्यीय खंडपीठांनी जे निर्णय घेतले ते सुद्धा इथे विचारात घेतले जातील, कारण ते कॉन्स्टिट्यूशनल बेंच होतं, 5 सदस्यांचं होतं. आता विचार करा, ह्या सगळ्या गोष्टी घडल्यानंतर, या सगळ्या गोष्टींची व्यवस्थित उत्तर दिल्यानंतर काय कुठली बाजू राहते? एकनाथ शिंदेच्या वकिलांची नेमकी काय बाजू असणार ही पाहायचीच आहे मला. पण लक्षात घ्या, सर्व फायदे घेतल्यानंतर म्हणजे कपिल सिब्बल यांनी हे सुद्धा प्रूव्ह केलं की 2018ची घटना आम्हाला मान्य नाही, हे त्यांनी त्यावेळेस सांगितलं ज्यावेळेस ते सगळे फायदे त्यांनी घेऊन झाले होते. म्हणजे त्याच कॉन्स्टिट्यूशनवर तुम्ही इलेक्शनचे फॉर्म भरले, त्याच कॉन्स्टिट्यूशनवर तुम्ही निवडणुका लढल्या, तुम्ही मंत्री झालात, तुम्ही मंत्रिपदाचे फायदे घेतले, तुम्ही आमदार झालात, तुम्ही मंत्री झालात, आणि त्यानंतर अचानक तुम्हाला 18ची घटना ही अमान्य ठरते. हे तुम्ही त्याचे फायदे घेतल्यानंतर ठरले आहे. त्यामुळे या सगळ्या गोष्टी केवळ योगायोग नाही. एकदा हा व्हिडिओ पहा.
We must inform the commission of the amendments. The only constitution that is taken on record is at the time of registration, because the guidelines to the commission say that you will have to, in that constitution, have a provision for amendment of the constitution. So, as and when we amend provisions, we inform the commission of what is amended. That's all. Though it is our case that we gave it along with the letter, but we can't now prove any of that. They deny it. But the fact of the matter is, where is that requirement? Moreover, the Election Commission erroneously held that the 2018 Constitution was not democratic. Based on these untenable reasons, the Commission has based its entire decision-making process on the legislative majority employed by the respondent. See the but see, the unjustness of this kind of a analysis. The Speaker doesn't decide the disqualification. The facts are clear. They are covered by a judgment of the court. They are covered by several judgments of the court. You don't decide it. The Election Commission disregards the organizational wing, decides on legislative majority, which should not have ever happened. That government should never have been formed because they were deemed to be disqualified. And then, the whole process takes place, and then they get everything, the party, the symbol, and these people in power are like a magnet, as your lordship knows. That magnet attracts a lot of disparate people, even disgruntled people or happy people, because they look for new prospects. So your 31 will become 39, and 39 will become 56. And if you let that happen, which is, I think it was, according to me, and we will in another case argue, this is a wrong procedure to adopt. To let the disqualification linger, hopefully in another case I'll argue that. Statutory requirement under 29A. Further, this is not in sync with clause such and such of the guidelines prescribed in exercise of the powers conferred by 324 and section 29A. In view of the aforesaid, the test of party will not come in the aid of this commission in deciding the present case.
Now you deconstruct this paragraph.
Yeah.
Deconstruct this paragraph. There are 3 grounds on which
Correct.
the party constitution is not reliable.
Yes.
A, non-communication.
Yes.
B, not being in accordance with the communication made by the
Right.
ECI,
Right.
its letter dated 19/10/89, and being in breach of paragraph 2 of the guidelines
Right.
prescribed by ECI.
Right.
And show us whether it's factually incorrect
Right.
or it's legally untenable.
Both. I will show both. I will show both. Both factually incorrect and legally untenable.
This is the summum bonum of your argument.
Yes, I will show it both factually and legally untenable. I'll show that. But first of all, Well, let's give this power to the commission. We've had enough powers with the commission. Let's give them another power and see the consequences of it.
We want to test.
Well, let's test it. But well, let's give this power to the commission that at a given point in time, they can say your constitution is unconstitutional. We will not deal with it. We will not look at it. See the consequences of that and the politics of this.
Bigger question will become then the entire party has to be derecognized.
Correct, to do it. Well, send me a notice that I'll read it. I will de-recognize you. You send me a notice. Please send me a notice. That's not.
The notice, Mr. Sibal. See the second ground. Second ground is 89. When Bala Sahab Thackeray, leader, was there, a notice was given.
Yes.
Now, what
He corrected it.
After that, you
He
have
corrected it.
indicated an amended constitution, but both of you claim there is an amended constitution.
No, not only that, he got benefit. He became a legislator because of that constitution.
Your affidavit
Well, let's kindly see. You take the benefit of it and then you say, now you'll not look at it. This is the argument. You became a legislator, you became a minister, you got a ticket from the party, you became a member of the Karani, and then you say, look, don't look at it.
It will not be the question of that your interest we conduct. The question will be the legality of the order of the commission.
No, Malaj, I'm sorry. This court has said if there are two people who claim under the constitution, you can't go behind it. There's a judgment of this court.
Lord, also, my lord, just apropos what has fallen from your lordships, election commission, my lord, there are 5 judgments of the election commission.
cannot go to the constitution.
Yes.
And number 2, my lords, where the other party
Has gone
also
the-
relies upon so-called undemocratic constitution.
You can't go behind it.
Then, my lords, election commission has said we can't get into the dispute, and we will go by what is there on the record.
Mr. Sibal, Mr. Kamath, we pointed out this paragraph
Yes,
for
madam.
you to respond.
Well, this paragraph is an act of genius to ensure that you don't look at the organizational structure. That's my answer to it as far as the reality is concerned. It's an area of.
More forensic approach.
Well, I'm sorry to say, we sit here not realizing the realities of what happens on the ground. And Malad, if we allow these realities to continue and give this part of the commission, the consequences will be very grave. That's all I can say. But I'll answer that question in any case.
Deal which is relevant.
Yes.
Yes,
Formation of opinion.
that's right. I'll answer, I'll satisfy you on all these terms. Next week.
Tuesday,
I have one request, my lords, except for Thursday, any other date. My lords, Thursday I am not.
Right now, Mr. Sibal is there.
Yes, yes,
शिवसेनेच्या कालच्या सुनावणीमध्ये 1 तास जवळपास 28 मिनिटांच्या ह्या सुनावणीमध्ये अतिशय महत्त्वाच्या गोष्टी घडलेल्या आहेत. यानंतर अनेक गोष्टी घडल्या, पण सर्वच्या सर्व इथे सांगता येत नाहीत. पण कालची सुनावणी ही अतिशय महत्त्वाची होती आणि मला वाटतं पुढची सुनावणी आता ही सोमवार किंवा मंगळवारी. आता सुप्रीम कोर्टाच्या पोर्टलवर ज्यावेळेस ही तारीख पडेल, पण मंगळवारची तारीख त्यांनी दिलेली आहे. आता ती ज्यावेळेस सोमवारचं कामकाज संपेल त्यावेळेस मला ती तारीख कन्फर्म आहे की नाही कळेल, पण मी तुम्हाला ही सर्व सोमवारी संध्याकाळपर्यंत हे तुमच्यापर्यंत पोहोचवेल की आपली तारीख मंगळवारची आहे की आणखी पुढे जाते किंवा बुधवारची राहील. पण ही तारीख लागोलाग आहे. तुम्ही एक गोष्ट लक्षात घ्या, काल गुरुवार होता आणि लगेचच मंगळवारची किंवा सोमवारची तारीख मिळणं, या अगोदर 2-2, 3-3 महिन्यांचे अंतर जायचे. त्यामुळे काय व्हायचं, मागच्या सुनावणीत काय झालं हे पुन्हा रिकलेक्ट करायला लागायचं. त्यामुळे त्याच्यामध्ये तो सिक्वेन्स राहत नाही. जे आपल्या लक्षात येते, जी घटनाक्रम आपल्या लक्षात येते, म्हणजे जे नव्याने ऐकतात, आता आपल्याला तर पाठ झालं कशानंतर काय आपल्याला सुद्धा जर कोर्टामध्ये उभं केलं तर आपण सुद्धा व्यवस्थितपणे तिथे युक्तिवाद करू शकू. पण शेवटी काय, सोनारानेच ते कान टोचावे हे केवळ केव्हाही चांगलं. आपण काही तिथे उभे राहणार नाहीत. हा अतिशयोक्तीचा भाग आणि विनोदाचा भाग आहे. पण तरी सुद्धा ज्यावेळेस ह्या गोष्टी वारंवार त्या ऐकल्या जातात आणि त्यानंतर मध्ये खंड पडतो, त्यानंतर ती लिंक तुटते. पण लागोलाग ह्या तारखा ठेवणं हे सुद्धा तुमच्या आमच्या पथ्यावर पडणार आहे. पाहूयात नेमकं काय घडतंय मंगळवारी, तुम्हा सर्वांपर्यंत घेऊन येईल. तुर्तास तुम्हा सर्वांची रजा घेतो. शिवसेना एक वादळ या माध्यमाला सर्वांनी सबस्क्राईब ठेवा. ज्यांना शक्य आहे त्यांनी या माध्यमाला जॉईन करा. जॉईन हा पर्याय सबस्क्राईबच्या अगदी बाजूलाच आहे. याद्वारे तुम्ही या माध्यमाचे सदस्य बनू शकता. आणि ज्यांना शक्य आहे शिवसेना एक वादळला सहकार्य करायचं आहे, त्याच्या सामाजिक कार्यांमध्ये सहकार्य करायचं आहे, आपण गुगल पे आणि फोन पे क्रमांक लिहून घ्या. 9987 70 34 18 9987 70 3418. तुर्तास रजा घेतो. सप्रेम. जय महाराष्ट्र.